A child's preference and parenting time in an Illinois divorce. One of the most emotionally charged questions in any Illinois divorce is whether a child can simply choose which parent they want to live with. The answer, perhaps surprisingly, is that no specific age or milestone automatically makes a child's preference the deciding factor in a parenting time determination. Under Illinois law, a child's wishes are just one of many factors a court weighs when determining what arrangement truly serves that child's best interests. Illinois courts have long recognized that placing the burden of choice on a child creates intense emotional pressure, feelings of disloyalty, and potential long-term harm to the child's relationship with both parents. For this reason, judges rarely put a child on the witness stand. Instead, when a judge does want to hear directly from a child, it happens privately in the judge's chambers through a recorded conversation. More commonly, Illinois courts rely on a guardian ad litem, a court-appointed representative who serves as the eyes and ears of the court, investigating the child's circumstances and bringing the child's perspective to the judge without forcing the child to choose sides. When parents try to influence a child's stated preference through gifts, manipulation, or involving children in adult disputes, courts view this behavior as deeply problematic and contrary to the child's best interests. A mature child's preference, when grounded in sound reasoning such as wanting to stay in the same school, maintain friendships, or remain in a stable environment, will receive meaningful weight from an Illinois divorce court. However, even a thoughtful and articulate child's preference is never binding on a judge, who retains full authority to order a different parenting arrangement if the evidence supports it. An immature child's preference, particularly one that appears rooted in manipulation rather than genuine reasoning, carries very little weight in a court's final determination. There is also a practical reality that experienced family law attorneys understand well. As children grow older and larger, physically compelling a child to comply with a parenting schedule becomes increasingly difficult. When a child refuses to participate in parenting time with one parent, the most effective legal remedy is often to pursue enforcement against the parent with whom the child actually resides, holding that parent accountable for compliance with the court-ordered schedule. Illinois law allows courts to impose additional conditions, modifications, and consequences when a parent has not complied with an allocated parenting plan, giving the court meaningful tools to protect both the child's well-being and the other parent's rights. Navigating these issues requires careful legal guidance from an attorney who understands how Illinois courts balance a child's voice against the broader framework of best interest factors. Whether you are a lawyer seeking to enforce a parenting order or a parent trying to understand your rights, the law office of Russell the 500th Knight is ready to help. So call 773-334-6311, located at 1165 North Clark Street #700, Chicago, Illinois 60610, United States, to schedule your consultation today.